Hi, my name is Mason Rashtian from the Mason Law Firm. So this morning someone asked me about discovery. He said he was watching a TV show and they mentioned discovery and he wanted to know what that meant. Simply said, discovery happens during a litigation case. When there's a lawsuit filed, each party is allowed to discover what the other side has as far as evidence, witnesses, and their theory of liability and or defenses. These are done in different forms. For example, interrogatories are written questions that each side gets to serve on the other side and ask them to answer those questions under oath. Another form of discovery is request for production of documents, where you ask the other side to produce whatever documents or evidence they have for their case. For example, a defense would ask the plaintiff to produce medical records, medical bills, photographs, right? And the plaintiff gets to ask the other side for the same thing. They would include photographs. In a slip and fall case, you want to find out if they have any sweep sheets, right? You want to find out if they have any witness statements. You want to find out if there's any police report filed. Those are the documents you usually ask for. There's also something called request for admissions, where each side gets to ask the other side to admit certain facts before trial, right? You can admit or deny them, or you can say, at this time, we cannot admit or deny those facts. Now, if you deny a fact and you go to trial and the other side is able to prove that fact, then there would be consequences as far as paying for the costs related to proving that fact. Another form of discovery are depositions. Depositions happen in person, or there's a question and answer session under oath from the attorney directly to the deponent. So what is the purpose of discovery in lawsuits? It is to prevent each side from surprising the other side with evidence and witnesses that they have not previously identified. Each side is supposed to know what the other side has before going to trial. It makes trial easier. It gives everybody the chance to know the weaknesses and strengths of their cases. So when you see a TV show where a surprise witness shows up and surprise evidence shows up at trial, that usually does not happen because each side is supposed to know what the other side has. My name is Mason Rashtian, and we meet our clients by accident.